Right. Good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us here today for Florida Crimmigration 101, a webinar for criminal and immigration attorneys. Before I introduce our speaker, I do want to go through some quick housekeeping announcements. This training is being recorded, so if you're registered, you're going to receive a copy of the recording via email from Zoom within 24 hours. I'll also be posting it on YouTube. So if you're subscribed to our FLS YouTube channel, you'll be notified that the video has been published. But if you bookmark the YouTube link, you can find the video after we post it. If you don't see that email, I'll drop my email into the chat just in case. The training was approved by the Florida Bar for one General CLE credit and one Immigration and Nationality Law certification credit. I'll announce the CLE code towards the end of the webinar. I will also drop it into the chat. It will also go out via email, and it will also be on the YouTube description. So it's going to be really hard to miss. This training is being co-hosted by the Public Interest Law section of the Florida Bar, or PILS. So if you're not familiar with PILS, I'm going to drop the information into the chat. Please check out our membership benefits. If you're an attorney, it's $55 a year. It's currently free for law students. So if you're a law student and want to get involved with public interest law, I highly encourage you to join. One of our most active work groups is the Civil Rights and Immigration Work Group. So after talking to them, they mentioned that this is a topic that is definitely a topic that we need guidance on in Florida. So if you're interested in that type of law, please take a look at PILS on our website, whether you're an attorney or a law student. So final piece of housekeeping announcements are questions and answers. If you have questions, you can use the chat or you can use the Q&A feature. We will try, our speaker, Ronald, will try to answer questions as they come in. So I'm going to turn my camera off, but if questions come in, I'll probably interrupt and say like, hey, here's a question. We do have a lot of content. So you will see like the presentation is over 60 slides and we have 1 hour. If we go over, we may be able to stay for a bit, but I'm going to drop the link to the materials as soon as I stop talking. So you have access to all the materials as well. They will also go out via email in case you missed them in the chat, and I will also include them in the YouTube description. So without further ado, I want to go ahead and introduce our speaker today. Ronald Mondello is a solo practitioner with offices in New Jersey and Boca Raton, Florida, a member of the New Jersey, New York, and Florida Bar since '93. He focuses his practices on crimmigration, the intersection of criminal and immigration law, and post-conviction relief for foreign nationals. He is the author of the widely referenced New Jersey Crimmigration Law and is currently working on a Florida edition. Mr. Mondello regularly advises criminal defense attorneys on safe haven pleas to help clients and avoid deportation, and he frequently lectures for bar associations and legal organizations nationwide. So, without further ado, it is my pleasure to pass it over to Ronald Mondello. Ronald, the floor is yours.
Thank you very much, Jorge, and I very much appreciate the invitation. It's an honor to be with you folks. So let's just jump right into it because I am certainly concerned we will not get through all of the materials, but we'll do the best that we can. And I know that Jorge will be posting a link to the materials. If you have any other questions, whether it's tomorrow, next week, 3 weeks from now, a month from now, feel free to give me a buzz. I love to talk crimmigration. So, as Jorge said, I am Ron Mondello, and I have been practicing crimmigration for several decades. Let's be clear, this is not an immigration course. There are hundreds of those courses out there, and this is not one of them. We will be talking about foreign national defendants. We have a lot to cover. If you came to learn, I promise you that you absolutely will. On the other hand, and I respect this too, if you came just for the CLE credits, I'll wake you after the class. Now, please feel free to ask questions whenever you have one. And I will certainly leave it up to Jorge if we are really behind in the presentation. We may save some of those questions towards the end. But whoever asks the most questions, I will electronically send you this bottle of Violetto Mondello blend wine. It is a Petit Syrah, a Cabernet Sauvignon, and an Alicante. And Violetto is a very loose translation in Italian for highway. And I used to make this with my grandfather, Arresto Bellotti, in the driveway. So that's about as close as I could get. All right, let's rock and roll through some of this stuff here. Let me get my, all right. So what is this crimmigration? It's the interplay, and these areas are very dynamic. They're constantly changing, and that interplay is complex. However, I did really try to break this down so that you can get your arms around it if you have never even heard the term. There are topics contained in this presentation that I could spend an entire day on. Um, Not in Florida, unfortunately, or maybe fortunately, I don't know, but I think it's unfortunately. But the PCR field has become a cottage industry for anyone who can type, and extremely difficult to win a PCR in Florida. New Jersey is difficult, but not close to some of the restrictions that Florida places on a judge granting a post conviction relief, which one of them is actually the foreign national must be here legally. I've never come across that before, but there's a case, Cano, C-A-N-O, I believe, that indicates that. So here's the intersection: criminal, immigration, the county courts, and post-conviction. Now, you never want to ignore the United States citizen. Your client may be one, just doesn't know he is. DACA, that's where folks have came here when they were under 16 years old, and I don't know, they were under 30 as of June 15, 2012. They went to school here. Deferred action is typically somebody like a drug dealer who's been very cooperative with the government and gives up bigger players, and the United States Attorney General gives them a pass. They put in their profile, do not deport. There are over 60 different kinds of visas, and as mentioned, we won't be touching base on any of those. There are plenty of immigration courses. All right, so the first and most important issue is that we must determine what the status of your foreign national defendant is. And there are two classes: those who were inspected and those who snuck into the country, or those who are returning from abroad. So you see the folks, the individual on the left here. Let me see if I can get my highlighter going. This individual was inspected, and these folks came across the border illegally. All right, so this term inadmissibility, I think it took me years to understand it, and hopefully we can accelerate your learning of this here. So inadmissibility, it's a legal fiction. Mere physical presence in the United States does not mean that the foreign national lawfully entered or was admitted. You have to be inspected and authorized by an immigration officer to be admitted. Therefore, you have not been admitted, even though you're here. And you can find the grounds of inadmissibility. Now, when I say grounds, what are we talking about? Criminal, and that's it, criminal. At INA section 212. All right, let's get to the next slide. That's an entry without inspection. We call those folks EWIs. There are 4 EWIs here, entries without inspection. So deportability, the second class. Is your foreign national subject to the grounds of inadmissibility or deportability? So a foreign national has been lawfully admitted to the United States, then commits a crime. They are subject to the grounds of deportability at INA section 237. So your foreign national criminal defendant, he came here legally, or she gets arrested, pleads guilty to a Florida criminal charge. He or she is now facing the grounds of deportability. Now, this would be a form of inadmissibility. Somebody coming from abroad, they face the grounds of inadmissibility if they have a criminal violation. All right, so that's an example of a green card, which, no, it used to be pink. I think it's pink now. But anyway, let's hope your client doesn't get the card that way. All right, so why on earth would a Florida criminal defense attorney or an immigration attorney have to know this nonsense about inadmissibility versus deportability? Well, there are very different immigration consequences between those criminal grounds of inadmissibility and deportability. For example, a Florida criminal conviction may not have the same effect on a green card holder versus an EWI. And when you spend some time with those two different sections in the INA, you'll see that it's almost a caste system. The government treats those folks with green cards a bit more generously when it comes to crimes versus EWIs, someone who snuck in. And finally here, a Florida criminal conviction may only affect a green card holder if he or she leaves the country and then returns. All right. Okay, so this is probably hard for you to see, but here's simply a way to determine whether or not your foreign national client is subject to the grounds of inadmissibility versus deportability. Where was the defendant born? United States. Okay, that takes care of that. Foreign country, assume the defendant is a foreign national. How did the defendant get to the United States? Border crossing, subject to the grounds of inadmissibility. And of course, it's a bit more esoteric. If they left the country, as we're going to see in a couple minutes, and come back, they're subject to the grounds of inadmissibility. Defendant was legally inspected, subject to the grounds of deportability. All right, let's take a minute here and see if we can get our arms around these two different categories. Mexican foreign national is here for 10 years. He got here via Coyote. If he gets pulled over for a DWI or DUI, he has coke in the car and ICE shows up. Is he subject to the grounds of inadmissibility or deportability? Jorge, I see there's, I don't know, it looks like there's 3 in the chat here. I'll leave it up to you whether or not we should address those questions at this point. To answer this question, and if it was a live audience, I'd ask for some hands. The Mexican foreign national is subject to the grounds of inadmissibility. Why? Because he snuck in. Okay. Now, a Polish foreign national gets here with a B2 visitor visa. It expires in 6 months. He gets busted for only simple possession of pot. Don't assume that, even though it's not legal in Florida. Well, I guess medicinal is, but not recreational. That failed. But that has nothing to do. The feds consider this a crime. So ICE shows up. Is he subject to the grounds of deportability or inadmissibility? Deportability. Why? Because he was inspected. All right, let's pick on the Italians. Italian foreign national with a green card. He's got a criminal conviction for theft. Criminal conviction for theft. He travels to another country for vacation. When he returns to, let's say, JFK, what is he subject to? The grounds of inadmissibility. A bit esoteric, because that person has a green card, but now that he has a criminal conviction, we start all over and decide, and ICE will decide, or the Customs Border Patrol guys will decide whether to parole him in or just detain them. Okay, if nothing else, this is a slide you should print out and leave on your desk. It shows how the 2 different classes, inadmissibility versus deportability, is a caste system. And I'm not going to go through all of this, but let's take a look at this first one. A conviction or admitted, not just a conviction, admitted commission of any controlled substance, a joint. That's it. An e-weed can get hot water for a joint. Come over here. Let's assume the folks have, the individual was either a green card or an H-1B or whatever. A conviction of any controlled substance. However, here we go with the caste system. The government gives them a pass and says, other than a single offense of simple possession of 30 grams or less of marijuana. Over here, you'll see we've got crimes involving moral turpitude. And then this one, they give them a bit more leeway, committed within 5 years of a lawful admission to the United States. All right. Okay. So on the other side here, something was called the petty offense exception. Well, what is that? Here it is. The petty offense exception is for inadmissible foreign nationals convicted of crimes involving moral turpitude, which we'll get into. Maximum sentence does not exceed 1 year, and you're not sentenced in excess of 6 months, regardless of the actual time spent in jail. A suspended sentence equals a sentence. All right. Now, I did show you over here these committed within 5 years. So let's take a look at that and explain that a bit further. So this is the get out of deportation card for deportable foreign nationals committed of CIMTs. Any indictable CIMT committed after 5 years of the lawful admission, they get 1 free pass. 1 free pass. It doesn't apply to aggravated felonies, which we're going to go over in a couple of minutes. So if that green card holder only has that one charge, they're in good shape. However, if they've committed two CIMTs any period of time, I don't care if it's within the 5 or whatever, that's it. They're subject to deportation. All right, this is a very important slide. The definition of a conviction for immigration purposes is very different than the definition in Florida. So, what do we have? A formal judgment of guilt of the alien. I always hated this. I always think of Star Trek when somebody calls a human being an alien, but it is what it is. Of the foreign national entered by a court, or if adjudication of guilt has been withheld, where the judge and jury have found the foreign national or the foreign national has entered a plea of guilty or nolo contendere, or here's the kicker, admitted sufficient facts to warrant a finding of guilt, and the judge has ordered some form of punishment. Could be virtually anything. Fines, probation, that is a form of punishment. I got that from a Pink Floyd show, so hold on. There we go. All right. So what does that mean for Florida convictions? Only a finality of conviction counts. So all times for direct appeals have expired. So what does that mean? So if your foreign national has recently pled guilty to an aggravated felony and they are going to get stuffed on a plane fairly shortly, and you are within that time period to appeal, if you file that appeal, that green card holder does not have a conviction for immigration purposes. Always understand that a PCR is collateral. The filing doesn't change the finality of the conviction. And in many instances, an immigration judge is not going to toll or wait or delay the immigration proceedings if, in fact, a PCR has been filed. Any type of PTI, pretrial intervention with a plea, I call them plea TIs. That's a conviction, and the immigration judge will indeed ask for a plea if they see that the foreign national, a transcript to see whether or not that foreign national has indeed entered a guilty plea. Juvenile delinquency adjudication, that's not a conviction, and you never want to take a juvenile foreign national who has been convicted or charged with a juvenile delinquency to adult court, unless, of course, you have no option, and the state has done that because the charge is so serious. All right. Okay, so when is a non-conviction a conviction? And I borrowed this slide, I think, from Jeremy. So withholding of adjudication of guilt is a conviction as long as some form of punishment, penalty, or restraint on the defendant's liberty. Court costs, we know this, count, and that's a matter of Cabrera, except in the Fourth Circuit. Restitution counts, and of course, fines count.
Ronald, there's a question related to the previous slide. If you can go back 2 slides. The question
Sure.
is, I believe it's, go back one more slide. The question is, how about for renewal of green card, I guess GC, so green cards would be the same analysis? Would the same analysis apply?
So I may not quite understand. I'm going to click on, I better not, otherwise I think the screen may change. I guess you can
So,
see that. How about for renewal of green cards? Would the same apply? Very interesting. Yeah, so when you go to renew your green card, you certainly do not want to give the advice to that foreign national who is convicted of a crime to renew the green card. So the answer is yes, because more likely than not, when they go through that process and they are asked to provide fingerprints or their fingerprints are taken and that crime pops up, there is especially in today's environment, there is a high probability that your foreign national defendant client will be placed in some type of detention. All right, or removal proceedings. All right, let's see, where are we here? We went over that. When is a dropped case a conviction? The out-of-court admissions to prosecutors, they don't count. Diversion programs with admission of guilt. However, admission, here we go, to the elements to a judge or a finding by a judge that the defendant committed each element of the offense counts. So even if it's not a guilty plea, for instance, I guess if a foreign national defendant want to exonerate his girlfriend, both were charged with some type of possession of cocaine. And even though the male foreign national defendant is not actually pleading guilty, but if he says, "Oh yeah, Judge, that cocaine was mine. It was in my pocket. It wasn't my girlfriend." Well, that's basically admitting to the essential elements of the crime. That's a conviction for immigration purposes. So admission to prosecutors filed with the court is a little bit murkier. And thanks again, Jeremy, for this slide. Best practice is to negotiate the admission out of the PTI agreement. All right, let's talk about crimes involving moral turpitude. Probably one of the most ambiguous phrases in a long list of ambiguous legal phrases. This type of conduct, well, mores change over time, but some of the conduct should raise, if you have it, hairs on the back of your head. It's inherently base, it's vile, it's depraved, it's contrary to the accepted rules of morality and duties owed to other persons, either individually or to society. So, in determining whether or not an offense involves moral turpitude, I see this a lot with criminal defense attorneys. It's a common mistake to consider whether the crime is minor or severe. Um, Intentional, permanent theft of a piece of bubble gum, that is a crime involving moral turpitude. That is a theft. Um, the facts of your client's case, they do not determine whether or not an offense involves moral turpitude. It's the elements found in that statute. And I've been doing this for a long time. You can give me a statute from Florida, New Jersey, New York, Alaska, and I will tell you whether or not it is a crime involving moral turpitude. Um, there is a process to do that. And I believe that some of the slides towards the end cover that. We may not get there, but if you have any questions, like I said before, you can give me a buzz. I'm happy to talk about what we call the categorical approach. All right. So, yeah, if it was the facts, immigration judges would be trying every single immigration case, criminal case in immigration court. They don't do that. They look at the elements of the statute, not the facts of your client's case. So the focus is on whether the elements necessary to obtain a conviction render the offense a crime involving moral turpitude. And here, you generally need a specific intent or knowledge of the acts the act being illegal. Recklessness might be enough. Negligence is almost never moral turpitude. All right, so let's talk about some Florida crimes that involve moral turpitude. So, we use that word permanent. So, theft when a permanent taking is intended. So, not joyriding. And it's not this case. It is A, right? But it's not B. And you can see this case for some authority. Now, burglary, if the house or the dwelling is occupied, that is a CIMT. And you can refer to this Board of Immigration Appeals. However, not this section, which is burglary, but it is unoccupied. The dwelling is unoccupied in Florida. So it is not a crime involving moral turpitude. And this case will provide you with the authority to that. Now, let's talk about fraud. You always need some type of an intent to defraud or guilty knowledge. And those sections are found in chapter 8, 17. It looks 01 through 85. Cashing or depositing items with intent to defraud. That's a crime involving moral turpitude. How about crimes of violence? Bodily harm is intentionally or knowingly caused or threatened. Most sex offenses are crimes involving moral turpitude. Now, you may find, especially in this environment, and there is some case law out there, that a DUI, which is not a CIMT in and of itself, however, if it is coupled with something like driving while suspended, where the defendant knew that his license was suspended, and there's the key, right? Knowledge, that could be a crime involving moral turpitude. Now, controlled dangerous substances, generally that is not a CIMT, but drug dealing is. Firearms standing alone, that's not a crime involving moral turpitude, but it is a separate grounds of deportability. All right, let's get into aggravated felonies. You'll see that the definition is found here in the INA book at section 101A 43. And generally, whatever deity your foreign national defendant may believe in, even if that deity were to decide to intervene, chances are they're going to be removed. So there's generally no relief is available. There are some exceptions. There's three categories. So offenses that are aggravated felonies by their very nature. Offenses that are aggravated felonies based on monetary amounts to the victim, and then offenses that are aggravated felonies based on the sentence or upon the sentence. So let's see if we can get into the first category and get some examples of aggravated felonies, the nature of the offense. Murder, rape, or sexual abuse of a minor are typically aggravated felonies. There can be some exceptions, but they're rare. Drug trafficking. So I put this up here just to, when the circuit courts get involved and sometimes do some very high level esoteric thinking way above my intellectual capacity, they come up with some very strange results. The Third Circuit found, and that's it was a New Jersey case. We have New Jersey has two different statutes: drug dealing within a school zone, and then regular drug dealing. The Third Circuit found that regular drug dealing was indeed an aggravated felony, but drug dealing within a school zone was not. And if we had another hour, we could, really dive into that and pull apart the analysis, but we don't. So firearms trafficking is a aggravated felony, and some states consider this to be a fairly minor violation, but immigration considers it extremely serious. If your client is running a prostitution business, that's an aggravated felony. Human trafficking, kidnapping, child pornography. However, I know in the Third Circuit they found that child pornography is not an aggravated felony, but there's a separate grounds of removal, child abuse, and they found that it is child abuse because those poor children have to deal with those pictures being out on the internet until they die. All right, let's get into the next category. The monetary amounts, money laundering involving funds in excess of 10, fraud or deceit where the loss to the victim exceeds 10,000, tax evasion where the loss to the government exceeds 10,000. And then finally, the sentence. So where the sentence imposed is 1 year or more. Sorry, that needs to be changed. So if you got 364 days, you're okay. 365, 66, et cetera, is no good. Theft, burglary, a crime of violence. We're going to see a case on the next slide about crimes of violence, possession of stolen property, U.S. passport fraud, et cetera, et cetera. All right. So what is this crime of violence? So there were two sections that under 18 U.S.C. section 16 for crimes of violence, and the Supreme Court struck down that section, basically saying that it was just too vague and it involved way too many crimes, and you couldn't actually put your finger on what that substantial risk is. So if your client is charged and convicted of this, that is no longer an aggravated felony. However, this is an offense that has an element, use, attempted use, threatened use of physical force against a person or property. All right. Yeah.
Ronald, there was a question. I guess I believe it was answered with this last slide, but the question was, what about domestic violence as a crime?
We're going to get to that. I believe that's a bit more, a little bit more detailed, but yes, if the crime of violence was in a DV context, that's an aggravated felony. If the crime of violence was not in a DV context, that's still an aggravated felony. We may have a bit more on domestic violence down the road, but you really need to take a look at, again, is your foreign national defendant subject to the grounds of inadmissibility or deportability, and the exact statute that they have been found guilty of in the context of that domestic violence offense. And there's a slide that will talk about when your client now has a temporary or a permanent restraining order in a domestic violence context. I believe that's coming up. So, all right. There's a wonderful, the Immigrant Defense Project, brilliant folks. There's a wonderful practice advisory if you're dealing with a crime involving violence, that particular section, which is void for vagueness. Okay, all right. So here we go. So the DV, in order for it to be deportable, must be a crime of violence at this section, which we went over. Now, here we are. If your green card foreign national defendant has a temporary or a final restraining order against them, and they violate that restraining order, it's a little bit more nuanced, but let's speak in general terms for now. If they violate that restraining order, they will be subject to that ground of deportation, violating a restraining order. And child abuse is, as we said, that's a separate grounds of removal. If your client is found with child pornography, that is child abuse. So generally, almost any act or omission with any mens rea, including negligence, that qualifies as maltreatment and harms a minor's mental or physical well-being with an actual injury. However, we've got some circuits that kind of go back and forth. The 10th Circuit says mens rea of negligence is no good. Second Circuit says that actual injury is not required. Generally, there are no issues with DUIs, but I want to point this out to you folks. I don't know what's going to happen to this particular bill, H.R. 875. The bill says this: if you are a foreign national and you have been charged or convicted of a DUI, you're going to be deported. Simple as that. I know that it had picked up a great deal of steam in Congress. It passed Congress. It is now with the Senate Judiciary Committee, I think. I think that's it. It seems to have lost a lot of steam. But if this passes, wow. And I know that, the courts disfavor retroactivity for criminal violations. They have no problem with it in a civil context. But I'm concerned in this environment that if it passes, your foreign national criminal defendant with a DUI is going to be put in removal proceedings, even if that DUI was 10 years ago. I hope I'm wrong. For now, let's see. Now DUIs for, in the Third Circuit, if you have a DUI for drugs, you can be deported. All right, what else do we have here? Let's talk about, there we go. Let's talk about controlled substance violations. Now, not all drugs are controlled substances. Illegal possession of cancer drugs from Haiti is a crime. It's not a controlled substance. It's got to be listed on this federal schedule. Otherwise, it's not a controlled substance. And the CSV, they're independent grounds of inadmissibility and deportability. We spoke about this already, right? Recall? You do not need a conviction or even an arrest when a foreign national is coming into the United States and somehow they were charged with drug dealing, but it got dismissed. And somehow the Customs Border Patrol guys I don't know how, but it's possible, have a copy of the police report that says they were indeed dealing drugs. If the Customs Border Patrol guys have a reason to believe that the foreign national trying to enter the United States is a drug dealer, they will be denied admission to the United States. So, green card holder returning from abroad convicted, or if they admit, they'll be denied. This one, I have not ever seen this, but that's what the law is. Crack or roofies, they are simple possession is an aggravated felony. 33 years I've been practicing, I've never seen anybody charged that way. All right, so this is boy, there's a lot of stuff here, and we are at 41 minutes, I think, or I don't know, something along those lines. I don't think we can cover it all. So resisting an officer, but these are Florida safe havens. So if you are representing your foreign national defendant in court, you want to try to take the bad offense and have them plead guilty to a safe haven so that their their immigration status is not negatively affected. So resisting an officer without violence to his or her person, here's the statute, right? Breach of the peace is disorderly conduct. That's safe. We've got this grand theft, this particular section, because joyriding, even by a driver, affects only a de minimis taking of the rightful owner's property. We conclude that it doesn't involve moral turpitude. And there are, this is some of the authority here. Simple vehicle flight, here's another one. We conclude that they do not define sufficiently reprehensible conduct to justify a CIMT. There's some other case law here. Assault or battery of a law enforcement officer and other specified personnel. There's no evidence showing that the officer suffered any actual injury as a result of the respondent's battery. So in re Edie Jose Ramirez. And we spoke about burglary. And if you can get unoccupied, and there's the 11th Circuit, you're safe. Felons and delinquents, possession of firearms, et cetera, unlawful. This section, the non-citizens Florida conviction under that statute did not fall categorically within the ambit of the federal firearms offense that subjected the non-citizen to removal. And that's Simpson versus the U.S. Attorney. Here's another one, prohibited acts, penalties. Florida conviction for possession of marijuana did not render the non-citizen ineligible for discretionary cancellation of removal. Great case, 11th Circuit. Okay. I don't see any other questions. I'm going to continue. All right.
Actually, we did have one. Can you go
Sure.
back one slide? We have one on the Q&A session. We have, what about trespass?
Typically, trespass is not a crime involving moral turpitude. You would have to send me the exact statute, and I could tell you with certainty whether or not it is a crime involving moral turpitude. I'm 95% sure it is not. All right. So preparing your EWI, entry without inspection, defendant charged with a DWI or DUI. So I'm told, and I have experienced this, that ICE is looking for your foreign national client that is charged with a DUI or a DWI. ICE is obtaining the names of foreign nationals charged with DWIs or DUIs. ICE is showing up at court waiting. Refusal appears to be safe, at least for now. I have not seen removal grounds in an NTA, notice to appear, on a refusal. All right, so keep your eyes open for that. Be careful. So here we go. So who's safe from a DUI? A U.S. United States citizen, a green card holder, again with the caveat that 875, if that bill passes, I suspect it's going to wreak havoc, and especially if it is applied retroactively. An EWI, absolute danger. An F1 student, it's discretionary. I believe they're in danger. The B1, B2 visitor, discretionary, but I believe they're very much in danger. The H1B, discretionary, but I believe they're very, very much in danger. All right, we're not going to get into this. That's the bill. take a look at it, read it, and keep our fingers crossed that indeed it never passes and that it continues to lose steam and dies out. I'm
Ronald,
seeing
we had a
this.
few que-
Go
we
ahead.
had a few questions. I wanted to make sure we didn't miss out on them. One
Sure.
question was going back to the crimes involving moral turpitude. What about if you have a license bought under the table that does not match the immigrant's birth date? If this is an issue, if so, how?
Yeah.
So
So
basically, a
again,
fake ID.
yeah, I need to see the statute. However, if the statute, and it may be divisible, it may have different sections. You'll have to send it to me. But if, let's say, the first section says we're charging you with X crime because you have a fake driver's license, that in and of itself is not a crime involving moral turpitude. Why? You didn't attempt to defraud anybody with it. It stayed in your wallet. It stayed in your pocketbook. The second section may say something along the lines you had a fake driver's license and you gave it to the police officer so that the ticket would be issued in that individual's name instead of that. Certainly is a crime involving moral turpitude. You defrauded and you had the intent to defraud that police officer with your fake driver's license. Absolutely a CIMT.
There's another question that came in through the Q&A. I believe this one was asked when you had the list of the DUIs, whether you're safe or not with the DUI. The question is B1, B2 with valid status or an overstay 2?
All right, so let me, I'm going to have to take a look at that question again, if you don't mind.
It's in the Q&A. Let me drop it into the chat just to make it easier to see.
Is it above the one that says the license? No.
Yeah, I marked it as answered, the one in the answer. I did drop it into the chat, the question that was asked. B1, B2 with valid status or an overstay 2?
Okay, and they were asking this in the context of a DWI, right?
I believe, yes, related to the DUI, yeah.
Yeah, okay. So the EWI, the entry without inspection, or the individual who has an overstay, I believe, and again, this is policy. Now, we're sometimes making a distinction between policy and law, because a DWI is not a deportable offense. However, policy, if they're out of status, they will actually, like an EWI or an overstay, in my opinion, ICE will be looking for them. With respect to the B1, B2, uh, they could get their B1, B2 revoked for having been convicted or charged. Remember, these are discretionary forms of relief. No one is guaranteed a B1 or a B2. And it's policy. And we know that the policy is certainly harsher right now than perhaps a few years ago. All right, did I cover them all, Jorge? I think
Actually,
so.
one more question came in,
Go
and I'm
ahead.
gonna read it out loud. It's an LPR has a DUI conviction from 20 years ago or more, but not an EWI, and wants to naturalize now. What effect? Should the LPR proceed with their application and then interview?
Great question. Thank you for that. Um, there is a case law, and you can send me an email. I'll get it to you. It escapes me right now. It was not in the context of naturalization. It was in the context of 42 A, cancellation of removal. And the foreign national had two DWIs. And the attorney general took the case and found that you cannot prove the good moral character component of 42A if you have two DWIs. I'm seeing that carried over to naturalization. I would never, ever try to naturalize my foreign national client if they have two or more DWIs. I'm not so sure I would try to naturalize them if they have one. But one is certainly a lot more safer than two. And I think two, it's going to be absolutely denied. And certainly, again, I'm sorry to bring it up, the caveat 875, if that ever gets passed, you would certainly not want to file for naturalization if that gets passed. All right, let's move on here. So ICE is in the immigration courts. We know, especially since mid-May, ICE has resumed arresting non-citizens at immigration courts. In fact, there's been some brawls. I don't know if you've seen, terrible. First targeting individuals whose cases were dismissed, now expanding to those with pending cases. ICE and the immigration courts are working in tandem to fast track deportations and subside the due process. Expanded powers, reversed a long-standing guideline that prohibited immigration raids in sensitive areas like schools, hospitals, churches. All bets are off now. Is pushing states to work with ICE so they can delegate its immigration enforcement duties to state and local police. And that was a no-no years ago. Okay, let's take a look at this fairly recent bill. Laken Riley and detention. This new law expanded mandatory detention. What's mandatory detention? You are detained without bond. To include certain undocumented people who have been charged, arrested, or convicted of theft offenses, including shoplifting. It's mandatory detention, no bond, right? And it also allows state governments to bring lawsuits and individual immigration decisions. It's unclear how this is going to play out in practice, whether or not it's retroactive. All right, this is the case that has all of the immigration attorneys up in arms. I mean, for decades and decades and decades, even a foreign national that snuck in was an iwi, an entry without inspection, was eligible for a bond. Not anymore. Those individuals are being held without bond. Immigration judges lack the authority to hear bond requests or grant bonds to aliens who are present in the United States without admission, are iwis. They weren't inspected. This is somewhat draconian. And I don't understand it because it's been this way for decades and decades and decades that certainly those individuals could get bonds, but not anymore. I'm sure that there will be challenges and we'll see how that winds up. All right, so the immigration enforcement in or near courthouses, they're now permitted. I don't know, some judges were arrested for trying to, I guess, uh-oh. It says my internet connection is unstable. I hope we're okay.
You froze for a little bit, but we can hear you fine now, so I'll let you know. I was wondering if it was me or you, but yeah.
No, I got this message that it was unstable, sort of like me. Anyway, all right, so you can review this. It's got a lot of technical stuff in it. We need to get to some more important stuff. Expungements. I am spending way too much time vacating expungements for foreign nationals. I'm not sure why, but many criminal defense attorneys think that an expungement will solve a foreign national's immigration problem because they have a certain conviction. It's worthless. Unless, of course, you have the entire file and they've got an interview with Google. Okay, that's the exception. But you should never be filing expungements for foreign nationals because all the questions on every form, even if your case has been expunged, we want to see the plea, transcript of the sentence, the judgment of conviction, et cetera, et cetera. So I spend way too much time vacating expungements, and I wish I didn't have to. So it's a no. All right, so I'm not going to spend a lot of time. Border security enforcement, right? We know that declared a national emergency at the southern border, revived the Remain in Mexico policy for asylum seekers. That's very different. Ended the catch and release. Now those folks are being detained. So it's led to a huge expansion of detention. Interesting enough, they've deployed the military. You got the Department of Defense, National Guard, been tasked with supporting border enforcement and construction, including completing the wall. Restricted asylum access. An order was issued to immediately deport migrants who cross the border illegally without allowing them to pursue asylum claims. And that's always been certainly part of the law. The Customs Border Patrol One mobile app, which had been used for scheduling asylum appointments, was shut down. And then federal agencies have been directed to prioritize the prosecution of criminal offenses related to the unauthorized entry and presence in the United States. Interior, so they broaden their deportation priorities. They're setting quotas. They have to deport 1,200 to 1,500 people apparently daily. Expanded the sensitive location areas. They've ended that policy. So now schools, churches, hospitals are in play. Extended expedited removal, which allows, of course, for the immediate, rapid deportation without a court hearing. And that's expanded to nationwide to cover undocumented immigrants who can't prove that they've been in the country for at least 2 years. And lawsuits have been filed challenging this expansion. And mandatory registration, an order directing all undocumented immigrants to register with the government, and non-compliance becoming a high priority. All right. So trying to end birthright citizenship, suspended the refugee program, targeted sanctuary jurisdictions. Those would be cities that claim to be sanctuary jurisdictions. Restored secure communities. That's a controversial program that shares fingerprints. And then targeted temporary legal status. It says Cuba here, and I've now, thank goodness, successfully represented 3 foreign nationals from Cuba that had orders of deportation decades ago, but just had to keep reporting to the ICE folks for decades. And then all of a sudden they got put in detention because of their conviction, and they were going to get sent to South Sudan, not back to Cuba. Cuba wouldn't take them, but luckily we were able to fix those criminal convictions, vacate those criminal convictions, and restored them with their families. All right. So the defendant will be asking you for these items for immigration. It's gotten much more intense, the request for evidence, RFEs, whenever you apply for almost any time of any form of relief, and your foreign national defendant has some kind of a arrest or conviction. All of this stuff. Sorry, these are New Jersey terms. I recently had to give a presentation to the New Jersey municipal court administrators. And if there's no original record, you got to go through this scheme and find out what's going on. Get the court administrator to say this. All right, so let's talk about the obligations of a criminal defense attorney. Everybody at this point is familiar with Padilla, and if the immigration consequences are crystal clear, distribution of heroin, your client's got 6 kilos, clear. Got to tell them, pack your bags. If you're found guilty, you plead guilty, you're going to be stuffed on a plane. If it's ambiguous, we're not sure. That case in New Jersey, drug distribution within a school zone, it's not an aggravated felony. They only need to say, listen, it may have some immigration consequences. You may or may not be deported. Perhaps you should see someone who specializes in crimmigration to get a better feel for what's going on. But now you must form of advice. It might not say you can't, and I don't know, attorney and not even being integration, you probably should be involved and understand. All right, so my favorite quote from Justice Alito: they must not give unreasonably incorrect advice. That should be a C, right? So I hopefully don't do this on a daily basis. All right, we know that none of this is retroactive. That's the date going forward for Padilla. There's some specific claims here: failure to advise, ineffective assistance of counsel when the criminal defense attorney doesn't do these things. They failure to advise on the consequences. We know it's not affirmative. In New Jersey, we have this case. Misadvice can be about any topic. I told you that the sentence was only probation. It turns out it's 5 years. That's a problem. These are some of the things that in the future we may look at out for: failure to defend against adverse consequences. So even if you know the axe is going to fall on your client's head, the criminal defense attorney needs to try, and I'm sure they do, try to see if you can get one of those safe havens. Failure to investigate, failure to mitigate a plea or sentence. If the sentence is 365 days, chop off a year, and maybe you've avoided an aggravated felony. And failure to negotiate, very similar. I think these all bleed into one another. Jorge, any other questions? I'm going to look at the chat here real quick.
Yeah, we do have a few
Oh,
questions, but we have technically like 5 minutes left. So I figured keep on going if you want to, and we can leave some time, even if we go a little bit over for questions.
this one's interesting. Why do you have to vacate the expungement? Oh, because I do a lot of post-conviction relief work. So that's one of my main reasons. If you're an immigration attorney, you need to do it, because when USCIS asks you for all of those documents, in this environment, they may not be satisfied with, oh, sorry, the matter's been expunged. Too bad. Go vacate it and let me know if the county prosecutor opposed it and you lost, or if you won. That's why. Interesting question. All right. Let's see. I want to touch base on this because it will be helpful for those that are interested in the categorical approach. This is the way you can look at a statute and make an argument that it's not a crime involving moral turpitude, or it's not an aggravated felony. So how does it help? This case, take a look at it. This case, Florida theft, Florida battery. And you are essentially analyzing the criminal statute. We could spend 2 hours on this. We can't. But the Florida statute of conviction: aggravated felony, firearms, crime of violence, CIMT, controlled substance. What is this? How did this categorical approach come about? Well, it started with this case, Taylor. And what was happening is a felon with 3 priors for robbery or burglary, followed by a gun conviction, 15 years mandatory. How does the
Yeah, Ronald, you're frozen. I'm not sure if you can hear me right now, but it appears you are frozen. Let's see. Okay, so I'm trying to wait on Ronald. Maybe it's me. Can anybody hear me? I'm asking in the chat just in case. Oh yeah, it's frozen, so we lost him. So while if we'll wait for him to come back if possible. So I'm just gonna take this opportunity to read out the CLE code out loud. The CLE code is 2508056N. So, and Ronald, we have you back. You dropped off. You froze during the last slide, so I figured something was happening. So I started reading out the CLE code. But if you want to pick up where you
I
left
think,
off, go ahead.
yeah, I mean, I'm happy to stick around. We don't have that much left, 58 of 62. So I'll continue. Those folks that want to drop off, thank you for attending. Those that want to stick around, great. All right. So a certain category of crimes having specified elements, not by crimes that happen to be labeled. The courts, immigration courts, they're not going to pay attention to how the state labels it. They don't care. They're looking at the elements. Crimes that have common characteristics, the focus is on, let's see if I can get this laser pointer back. Come on, where are you? There you go. No. There. The focus is on the elements, not the actual conduct. And now we know it's an immigration court. So if the Florida statute of conviction is all of the elements match up the federal generic, that's it. It's a categorical match. And if it's not, if we've got some overlapping, you got to look at the statute and see, was your client convicted over here or over here? This is safe. This is not safe. So here we go. The statute of conviction and then the federal generic. The elements don't match up. You win. Now, when the elements of the Florida statute of conviction and the federal generic conviction, when they all match up, you lose. And when you've got the Florida statute of conviction and the federal generic, there's an overlap. You have to look to the record of conviction and try to figure out, is your client over here or over here? I should say over here. All right. There we go. Am I still frozen?
No, you're good. You're good. We actually have a few questions. Let me go ahead and there was one request to read the CLE code out loud. So it's 2508056N as in Nancy. So I'm also going to drop Ronald's information in here. His email is in there in case you have any follow-up questions. But I'm gonna go ahead and start picking the questions as they were coming in. Um, you've already answered the one on the expungement. There's one on the Q&A where the question is, would two petite theft convictions render a green card holder deportable if filing for renewal? Is there a time frame to look at?
Yeah. So take another look at that slide. And I did take everything down so that maybe it's a little bit clearer. And now I can see the chat a lot better. But take a look at that one slide that talks about two CIMTs. That's it. Two shoplifting offenses, they're going to be placed in removal proceedings. So I'm try to get rid of one of them.
Right. There was one
All
farther
right.
back, I think around 1246. The question is trying to renew green card. Client has a petite theft within the last 5 years, another petite theft not within the 5 years. She also has multiple withheld adjudication of fighting, disorderly conduct, battery not within 5 years. Would she be deportable when trying to renew the green card?
Yeah, so that's a case that's so specific, but I'll tell you with the two theft offenses, if they are permanent takings, they're deportable. Forget all the other stuff, that person is subject to deportability. Now, they may be eligible for 42A, cancellation of removal, but they're deportable.
Right. And the last
Right.
question, I'm hoping I didn't miss any other questions, but there's one more here. What are the attorney duties regarding informing a client about the alien registration requirement law when attorney is providing advice only or evaluating someone's case? And the second question is how knowing this law affects an immigrant if deciding not to register after learning about this law, knowingly and intentional elements.
Wonderful question. Go ask an immigration attorney. My specialty is crimes and immigration. I have no idea. Um, there's plenty of courses out there. Yeah, I'm sorry. I know that is a requirement, but that's my knowledge stops there.
All right. We have another one that just came in through the Q&A, and the question is, if a client is overstayed on his or her visa, if they have a DUI charge, is he or she deportable?
All right. So, and it's me. I have not been crystal clear. So, a DUI is not a deportable offense. That's the law. If HR 875 becomes the law, then yeah, it is now the law that it's a deportable offense. Let's talk about policy. It is this administration's policy to get rid of any undocumented B1, B2 overstay, I'm going to say H1B and many other categories that are charged or convicted of DUIs. That's their policy. Think about it. The overstay is deportable because they've overstayed. So they don't even need the DUI. But now that individual, his or her priority with respect to being removed has been increased tenfold as a result of the DUI. I think
Okay.
that's it, Jorge. Yeah.
Yeah, I don't think we have any other open questions. I want to take this opportunity to thank you, Ronald. I know we were before we started the webinar, we were talking about pro bono month and all of that. So I kind of wanted to give you the opportunity. If any of us have questions or potential cases with these type of issues, how can we reach out to you?
Yeah. So my I have I'm old. I have a landline in my home office, and I pick it up pretty much 7 days a week because that's the hours we're putting in these days. I can give that number out, or I can put it in the chat. That would probably be the best thing. Yeah, I would welcome any type of crimmigration pro bono. Don't ask me about asylum. I don't even know how to spell it. But crimmigration, that stuff I know. All right, there it is. Did that come up? Yes, it did.
Yep,
That
it's
is
here. I'm
my
gonna copy it on my end. That I'll add it to the email that goes out to everybody. So there's another question: how can we get access to this recording? So if you're registered, you're here. You're going to get an email from Zoom within 24 hours with all the information. It will include a copy of the recording that's posted on YouTube. I will include a link to the same link to the materials that I sent out earlier. If for whatever reason the email doesn't go out well, Zoom sometimes doesn't play well, I will also post it on YouTube. And what I've been doing on our YouTube channel is that I've been including the CLE code plus the materials as well. So if for whatever reason you can't find the YouTube channel, feel free to email me. I'm gonna drop my email here into the chat. We will find a way to get you a copy of this recording. It's going to be on YouTube, so if there's any other colleagues that need to take a look at this, they can definitely take a look at the video in case they didn't have a chance to watch the recording. And I know Ronald mentioned that he's writing a Florida version of the book. I have the cover the cover for the book on the materials, but I know Ronald mentioned that once he finishes it, we can share it with people uh, that registered for this training. So I'm gonna go ahead and drop my email into the chat as well. Sorry for the all caps because I already had it that way, but I'm not screaming. I promise.
Yeah, I hope hopefully the book will be finished by some point 2026. I'm guessing maybe February, something like that. It's about 70% done. All right.
Right.
Well,
So I don't think we have any other pending questions. Ronald, thank you so much for joining us today. It's always great to learn a new topic. When I first heard the term crimmigration, I was like, is that made up or is that a thing? And it turns out it is a very real thing, a really complicated topic. So we thank you for joining us today and sharing all your expertise with all of us. And thank you everybody that joined us here today. So with all that said, have a great rest of your day. Thank you again, Ronald.
thank you very much. And that term was coined by Julie Stump, who was a Rhodes Scholar many, many years ago, I think 2006. Take care. Thanks again for the invite.
All right. Thank you. Bye bye.